Can you please state your name and the position that you're seeking?
My name's Jason VanDyke, and I'm running for Wise County Justice of the Peace, Precinct 1.
What required training does Texas law mandate for JPs, and how will you go beyond the minimum requirements?
Texas law requires that justices of the peace do 80 hours of legal education in their first year in office, and I believe 20 hours every year after that. I am the only attorney who's running in this race. I'm very used to continuing legal education. I've done continuing legal education as an attorney my entire career. I've would certainly take advantage of the CLE courses, not only offered specifically for JPs, but for lawyers generally. I regularly attend the advanced criminal law course that's offered by the State Bar of Texas every year, as well as the collections and creditors' rights and the consumer law course. Those would probably be the courses that would be most relevant because there is traffic tickets and other Class C misdemeanors handled by the court, but a large part of what it does is civil litigation, which is claims 20,000 and less, evictions, things of that nature. And it's important to have a justice of the peace that stays up to date with the law. We get the Texas Bar Journal as attorneys, which helps keep us up to date. And I know we get a stipend as justice of the peace. We get a judicial stipend, and a lot of people think that lawyers just have the law memorized. They don't. We have books. I'm going to make sure everything's up to date in that office, even if I have to use my own money, so that we're playing with the latest sheet of music that we can.
Texas JPs serve as magistrates and they conduct inquests. So, how do you approach these responsibilities, especially in sensitive cases?
Inquests need to be dealt with very gingerly. Obviously, that's someone's loved one who has just died. Um, with respect to the inquests, obviously, I'd be leaning a lot on what doctors, EMTs, and medical professionals have to say. I am not medically trained. I'm an attorney, and so I would lean a lot on them and on what maybe the religious beliefs for a person are. Some people might not want an autopsy, and I'm going to have to make a decision because if it's a situation where there might be a criminal investigation warranted, I may or may not be able to honor that. It depends on the law. The magistrate thing, I've done criminal defense my entire career. This is very important for public safety of the people of Wise County because a lot of people think you look at the offense and you set a certain amount for bond. Well, that's not all you're looking at. You're looking at that person's criminal history. You're looking at any history of failure to appear in Wise County. You're also looking at their ability to pay bond. A lot of people don't know, but the Code of Criminal Procedure says that their ability to make bond, because they are presumed innocent until the state proves the case against them beyond a reasonable doubt. So that is a factor that you look at. And so as JP, there might be a situation where if that's the case, I have a little bit lower bond, but they've got bond conditions. For example, interlocks on for drunk drivers, conditions restricting the use of firearms for people accused of domestic violence or violent crimes. There's a broad range of things that JPs have discretion to do for bond and bond conditions.
What changes, if any, would you advocate for at the county or the state level to improve JP courts?
Simply put, first of all, there's been some talk about raising the jurisdictional limits. It's currently 20,000 for civil cases. I would say no to that. I'm kind of talking myself into a lower position here. I actually think that 20,000 is too much. We're the second highest in the country. 20,000 is a lot of money. I'd like for us to go back to using the rules of evidence in justice of the peace courts. I've got the discretion to allow it to require that, and I probably would as JP, but it's not necessarily required. And 20,000 is a lot of money for some people. I think also that I don't want to make people inconvenienced by going to court. That's not part of the process. Should not be part of the punishment. A lot of courts have gone back to in-person since the pandemic. I don't want people to have to incur extra attorney fees or take time off of work. I'm going to let people appear by Zoom when I can do it in a way that's conducive to getting the court's business done efficiently. Obviously, if some things there's going to be a live hearing that's going to be necessary, this should be in person. But I want the justice of the peace court to be accessible to everybody and as painless as possible for the citizens, because most of them is their first encounter with the justice system.
What role should discretion play in minor criminal cases?
Well, there's a great role for discretion. I think the first thing you're going to look at is a person's criminal history. If a person has a long criminal history, I mean, you've always got discretion. You might decide that case a little bit differently. Again, if it gets to punishment, the state first has to prove the case beyond a reasonable doubt. And it would never be my role to say, well, this person committed this offense before. They probably did it this time. That's not the law. But if they were proven guilty and I was my role to assess a punishment, typically a fine, I'm going to look at the circumstances behind the case. Every case is different. I can't just say here, oh, for this offense, it's going to be this punishment. That would be unfair. I have to look at the whole person. I need to look at the circumstances and taking all those things into account, decide what an appropriate punishment would be in a minor criminal case.
And I'll just restate because I think it might be the nature of the way the question was written. What about discretion in the role of criminal cases that involve minors?
Well, that involve minors. I think there's room for. In fact, the law I think mandates a little bit more discretion there. The role of the juvenile justice system, and I do practice juvenile law, is primarily to rehabilitate, not to punish. Frankly, I would want to be a scary enough figure for a juvenile offender and put enough fear into them that they never want to come back and they want to walk the straight and narrow. That doesn't mean a harsh punishment, but there's ways judges can scare people. I've seen it happen in a lot of my juvenile cases because we want them to be productive members of society. So they might get a lighter sentence than an adult offender because I know that the human brain's not fully developed. They're well beyond their juvenile years. Now, I want to make them sure that they know that this is serious. A court appearance is a serious business, and then they're going to become productive members of society. They'll look back on it and say, Judge VanDyke wasn't such a bad guy. He wanted what was best for me, and I understand why he was tough.
What languages or accommodations should the court be prepared to offer, and how will you ensure that that happens?
I think that especially that in cases interpreters need to be provided. While I personally believe that English should be the official language of the United States, that's not the law. And in a criminal case, a person has a constitutional right. They need to understand the proceedings in their native language. We have interpreters at Wise County. I've represented people that don't speak English before. I've used interpreters from my office or provided by the county. That's an important thing because just because they don't speak the same language as I do doesn't make them less of a person, and it does not make their rights any less worthy of respect. So I would certainly have interpreters there, be it Spanish. I know I've got a Chinese client now, even sign language. I think should be accommodated. I mentioned the Zoom hearings. There might be people who are uncomfortable with technology or disabled, and I want to make the courts as accessible to them as possible because this is their court. It's not my courtroom. They might say, "All rise" when I come into the courtroom, but I kind of don't like that. That's not my courtroom. That's the people's courtroom, and I'm not going to forget that.
I'd like to ask one follow-up question on the Zoom meetings. Do you have parameters or guidelines on how would you ensure that somebody appearing on Zoom is getting the same exact treatment as somebody in person in that you can't see who's outside the camera range?
That's something that you're gonna that a lot of times it's gonna be by honor system. For example, one really good thing for the Zoom type as far as hearings like trials in a criminal case would not be by Zoom, but there's a lot of things that could be by Zoom. Someone might have a pretrial hearing in a criminal case where it's just them and the prosecutor. They can go into a room on Zoom, talk about the case to the prosecutor. Prosecutor says, "Hey, we've got a deal. Here it is." Very well. That's the order of the court and everyone's satisfied. There might be a civil case where we have two attorneys. They're members of the bar. I trust that they're going to be honest with the court. They might want to have bring a motion to my attention, maybe for summary judgment, for default judgment, ask me for discovery. That's not something I need to make those attorneys come to court for and charge their client for that. They can very easily do that for the office through their office. But if we're having live testimony, meaning there's witnesses coming in that either myself as the trial court judge or the jury as the fact finder in a case need to decide the credibility of, those are going to be in person. I think you need to see somebody in person and see their body language and their mannerisms to make a good determination of their credibility. So for live testimony, yeah, that's going to be in person. But if there's something where there's not going to be live testimony, it's more administrative or ministerial. I don't want people to have to take time off of work for that. I don't want them to have to pay their attorney extra to drive all the way here. I know there's attorneys in Wise County that have their office in Denton. I live in Wise County, but I've got my primary office in Denton. I don't want people to have to incur unnecessary attorney fees. That's being a good public servant.
Why should voters trust you with this responsibility?
I've been licensed to practice law in Texas for nearly 19 years. I'll be celebrating my anniversary on February the 7th of this year. There'll be 19 years practiced. I'm licensed in Colorado, Georgia, District of Columbia. I can practice before the Supreme Court, multiple federal appellate courts, and federal district courts. Been to law school. I've been vetted. There's people out there that say some things about me, and I get as a candidate that's part of the job. But I'd ask them is talk to some of my clients, track them down, ask them how good of a job I did on their case. You talk to them, you talk to my staff, they're going to tell you that I'm the first one in the office in the morning. I'm the last one to leave. I treat everyone very well. I care about their cases. I care about them because they're people made in God's image. And that I'm going to work really hard to basically represent the people of Wise County as their justice of the peace as honest as I can.